So in last video, you must have gone through 14, 15, 16, 17, sorry, 12, 13, 14. So today we'll be covering 15 to 18. Okay. So Article 15 deals with Article 15 deals with prohibition of discrimination on these grounds. The grounds of religion, race, caste, sex, or place of birth. These are the only grounds where you can't, the state cannot discriminate. Okay. So the first clause says the state shall not discriminate against any citizen on grounds only of religion, caste, race, sex, place of birth, or any of them. So there is no grounds other than these 1, 2, 3, 4, 5. Okay. So discrimination cannot be done on these grounds, 5 grounds. Okay. Clause number 2, no citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to this: access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing huts, roads, and places of public resort maintained wholly or partly out of government funds, state funds, or dedicated to the use of general public. Word by word you have to go. Okay. So there can't be any discrimination on these basis. On these are the categories to these things. It is clearly mentioned in the constitution. Okay. Shops, public restaurants, hotels, places of public entertainment, use of wells, tanks, bathing huts, roads, and places of public resort maintained wholly or partly. So this is also very important term, partly. It does not mean ki it has to be wholly taken care out of state funds. It can be partly also, or anything which is for general public or public use. Nothing in this article shall prevent the state from making any special provision for women and children. It means the constitution is saying the government also can make any special provision. So it means it is a discrimination, but it is a positive discrimination. They can make special provision for women and children. So here the clear cut simple language will be, if the question comes, yes, in Article 15 we say we can't discriminate anyone, but yes, a special provision is there for women also in clause number 3, for women and children. For women and children, you have to see, the thing is, in Article 15 what happens is we only read the first 2 clauses. There are other clauses also, and questions are generally made from the other clauses, in particular prelims. Okay, even in state exams. Fourth, so in fourth clause, nothing in this article or in clause 2 of Article 29, that is for that cultural and educational rights of minorities, okay, shall prevent the state from making any special provision or the advancement of any socially and educationally backward classes of citizens, or for the scheduled caste and scheduled tribes. So it means, it is saying that the state can also make special provision for the advancement of any backward classes who are socially or educationally they are backward, or for scheduled caste and scheduled tribe. Any special provision. Here nothing specific is mentioned. Here this special provision, nothing specific is mentioned. For promotion and promotion, reservation, those things will come in Article 16. Okay, you have to be very clear on that. Here they can make any special provision, okay, for their advancement, for scheduled caste and also for scheduled tribes, and also for socially and educationally backward classes. 3 things you have to remember. Okay. Nothing in this article or in subclause G of clause 1 of Article 19 will come to that, shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens, or of scheduled caste or of scheduled tribe, in so far as such special provisions relate to their admission to educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions mentioned in Article 30. So it is a very important clause. I'll tell you exactly what is mentioned. It is saying the state, means the government, can make any special provision, obviously by law, for the advancement of educationally socially backward classes, scheduled caste, scheduled tribes, insofar as that special provisions which the government is making, it has to be related to their admission to educational institutions. No, so it is, so in clause 5 it is specifically mentioning about this admission to educational institutions, including private educational institutions also. So obviously if it is private, so it has nothing to do with the state, right? Because it is private, so whether aided by the state or unaided by the state, but other than the minority education. So minority educational institutions are not covered in clause 5 of Article 15, because minority educational institutions, they have a separate article in Article 30 which we will be covering. So that is the exception in clause 5. Getting? Okay. Now coming to clause 6. Nothing in this article or in the subclause G of 1 of Article 19 or anything Article 29 shall prevent the state. So it means the state can also make any special provision for the advancement. Now this clause was added recently for this EWS section. You must be knowing about the EWS section. So the amendment, though they did the amendment, I guess it is 103rd constitutional amendment, if I'm not wrong, 103rd constitutional amendment. So any special provision for the advancement of any economically weaker section, other than the classes mentioned in clause 4 and clause 5 we have already covered, like scheduled caste, scheduled tribes, then socially and backward educationally backward classes. Other than them, so they added a new thing. Okay, they can make special provision. The state can also make any special provision for the advancement of any economically weaker section of citizens, other than the classes mentioned in 4 and 5. Okay? Insofar as such special provisions, now those special provisions which the government is making, it has to be related to their admission to educational institutions, including private educational institutions, same thing, whether aided or unaided by the state. Again, other than, now here we are only mentioning about because all these things have already been mentioned about socially and backward educational class, backward classes, social, scheduled caste, scheduled type, already done. Now we are adding this clause through a constitutional amendment about the EWS section. So we have to mention everything for them also, right? So same thing. Those special provisions has to be about their admission. This is now, here we are not talking about reservation. We are not talking about reservation. Reservation will come in Article 16. Same thing. We are only talking about admission to educational institutions. So admission to educational institutions of EWS comes in Article 15. Reservation of EWS comes in Article 16. Okay. So same thing, whether like it can be also private, it can be also including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions, because minority educational institutions have different article in Article 30. Okay, which in the case of reservation would be in addition to the existing reservation and subject to maximum 10% of the total seats in the category. So here clear-cut reservation thing is not mentioned. Reservation will come in Article 16. So just you need to remember from exam specific, we have in Article 15, we have socially and educationally backward classes, number 1. We have scheduled caste, we have scheduled tribe, we have EWS. And about what? Special provisions. We have special provisions about them. Okay, it will help you in mains answer writing also. Special provisions about them. Now this special provision has to relate to admission. In admission also reservation happens, right? Now this reservation is about admission. It's not about exam. Remember. Now the reservation we're talking here, it's everything has to be with respect to admission to educational institutions, whether it is private, whether it is public. That's it of Article 15. Only this much concept you need to remember from exam point of view. Okay. Fine. So just one thing. So how this clause 6 was added, just we need to know because it is a current affair. Okay. Recently it happened. So clause 6 was added recently when the EWS category was added. In UPC also we have this category. Okay. So this is the explanation. For the purpose of this article and Article 16, economically, so this article means Article 15, and also in Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of the family income and other indicators of economic disadvantage. So they will time to time they may change it also. The state can change it basis on the family income. Now they have some criteria, some like yearly 8 lakh income has to be there, some land has no need to go there in detail, but just you know, right? You know, because there is a criteria, 2 to 3 4 criteria are there. Land, some land, if you are having this much amount of land, then only you will be eligible. If you are less than 8 lakhs, then only will be eligible. Okay. So Article 15 states there, number 1 states that the state shall not discriminate against any citizen on the grounds only of this. Okay. And this Article 15 is available to only citizens. It's not available to foreigners or non-citizens. It's only available to citizens. Article 15 provides that if discrimination is on any of the grounds mentioned here, then it is not allowed. But it is on any other ground, then it is not prohibited. The meaning is only, it has to be only on the basis of this is the ground. No other ground other than mentioned here in the Constitution. Okay. Therefore, in the case of some case was there in 1954, the court said that Section 497 of IPC, which punishes men only and not women, is valid, as it is discrimination not only on the ground of sex and also on the social condition of women. Now, this 497 is adultery. We have already covered adultery in the last class. Now, adultery is not a criminal. They have not criminal offense, and they have made it gender neutral. Okay. Now in these cases are not required. These are very okay. This case is recently. This is the case. The 150 years old version of criminalizing adultery was scrapped, so it was unconstitutional. Now they have made it. Now it is a civil offense. By the way, adultery is a civil offense. It is not a criminal offense now, and they have made it gender neutral. So adultery as a different topic. You can read it for a men's point of view. And Article 15(2) prohibits discrimination at public places which may be in control of even a private individual, because it is available against the state and also against private individual. So if a private individual is also like discriminating on the basis of this grounds, then also you can move to the court. It is not only against the government, against the private individual. Okay. Article 15(3) is an enabling provision. It merely gives discretion to the state to make provision for the welfare of women. Now the thing is, Article 3, what Article 15 clause 3 says? It says about special provisions for women and children. Just I told you. Okay, women and children. So in women and children, so if the government does not make anything, so you children or women cannot go to court and say it is my fundamental right, the government has to do it. No, it merely gives a discretion to the state to make provision. It is not an enabling provision. Nothing, the state is the exact word is nothing in this article shall prevent a state in doing this provision. The government can do. Okay. So it gives a discretion to the government. The government can do. Okay. The state can also make special provisions for any socially and educationally backward classes, scheduled caste, scheduled tribes under Article 15(4), and it has to be related to the admission. Okay, admission into public or private institutes. However, neither Article 15 nor Article 15 clause 3 nor Article 15 clause 4 impose an obligation or duty on the state to do so. That's what I said. It is not an obligation. It is merely a discretion to the state. Discretion to the state means the state can do any special provision. It is not imposing, it is not compulsion on the state ki you have to do it. The state may do if the state finds it apt to doing it. If the states find it okay, now the condition has come, we have to make some provisions for the upliftment of the women or the children or something. And similarly, it does not confer any right or even fundamental right on women. Yes, that's what I told you. Can't go simply ki this is my fundamental right, the government is not doing any special provision. You can't do. Okay. Similarly, it does not confer any right or even fundamental right on women and children also. Not even social and educationally backward class, not even scheduled caste or scheduled tribe. It is not a fundamental right on them. If the government may do. If the government finds it correct, the government may do. So you have to be very clear in the statements, in particular to prelims exam of any exam. Okay. Fine. So these are the clauses of Article 15. So this one is not required. So clause 6 was added. So 15 clause 6 was added recently to provide reservations to the EWS. Now in Article 15 it was added for admission. It was not added for reservation while giving exam. No. It is providing reservations to EWS for admission. You have to be very clear, to admission of to educational institutions, including private educational institutions, whether aided or unaided by the state. But minority educational institutions are not coming under the ambit of this. Okay.
So, sir, for employment, this is not included.
I told you employment is Article 16.
Okay.
I told you, na, employment means why that exam is nothing but employment. Article 16, we'll come to that. Okay. Here only educational institutions. Okay. Then this amendment provides reservation to those who do not fall in the category mentioned in 5 and 4. In 5 and 4, the categories are SC, ST, and educationally and socially backward classes. Okay. Now, for availing the above benefit, the gross, now the government has made some provisions. The gross annual income should be below 8 lakhs and they has to minimum own less than 5 acres of farmland. Then only will be eligible for EWS category. Okay, this clause was added by the 103rd Amendment Act 2019 and the constitutional validity of this amendment is challenged. Okay, it was challenged in court, right? So various writ petitions taken by the Supreme Court in the case of, this is the case name. You have to remember, this case name you have to remember because it is in current affairs. Youth for Equality versus Union of India. Okay. Youth for Equality versus Union of India 2019. In these writ petitions, it has been argued that this amendment violates the basic features of the Constitution and violates the fundamental right to equality. So the petition said ki if you are doing EWS, then it is not equal. Like a lot of people, it is not equality, right? You are giving preferential treatment, they said. But the Supreme Court has given this argument. In particular, they have propounded these are the arguments. Okay, these are the arguments. You can use it in your mains answer writing. The arguments are: reservations cannot be based solely on economic criteria. Okay, reservations cannot be based solely on economic criteria given the Supreme Court judgment. Now Indira Sawhney case will come today, only will come to that. It is related to that reservations, very important case of 1992-93. So they said ki reservation, now here 8 lakhs, 5 acres of farmland. Now this is an economic criteria. Now you are doing a reservation based on solely on economic criteria, which is not good because you are taking only one criteria. Okay. Even the Supreme Court in the Indira Sawhney told ki you have to take a lot of criteria. You cannot take only one criteria. Okay. SC, ST and OBC cannot be excluded from economic reservation as this should violate the fundamental right to equality. Okay, though you are giving this economic reservation to only EWS, this particular thing, you are not giving to SC, ST, so you are excluding them. Okay. So again, it is violating right to equality. The amendment introduces reservations that exceed 50% ceiling. Indira Sawhney case mein, the Supreme Court said ki to total ceiling should be 50% reservation. Now it is already 49%. Now again you are adding 10%, so it will be near to 60%. So it is violating Indra Soni judgment. Imposing reservations on educational institutions that do not receive aid violates the fundamental right to equality also. So these 4 points you have to write in your, when the question comes in a, you have to write the plus and minus. You have to write the favor and criticism. So you have to use these points, which will be directly help you in your mains answer writing. One point you have to write. Okay. Now the case is going on. We can soon get a result on this. Okay. Now come to Article 16. Article 16 is very important. Okay. Conceptual hai, so you have to remember the provisions. Okay. So here the equality, now here it is related to public employment. Article 15 was related to equality. Now there are some provisions related to admissions in institutions, but Article 16 comes with equality of opportunity in matters of public employment. So first is there shall be an equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Under the state means, now here under the state means government. Okay? No citizen shall, on grounds only of religion, race, caste, sex, descent, places of birth, residence or income. Now here the grounds have increased 1, 2, 3, 4, 5, 6, 7. Now here 7 grounds. They have added this. Okay? They have added this. Place of birth, residence, they have added this. So you have to be very clear which are the grounds for Article 15, which are the grounds for Article 16. Okay. So first is no, like everyone has like equality of opportunity they will have. Second is these are the grounds. Now coming to third, important. Nothing in this article shall prevent. It means the Parliament can make law, any law, prescribing in regard to a class or classes of employment or appointment to an office under the government of any local authority within a state or union. So it means government, any government, not only central government, not only state, not both, all governments, local authority also. ठीक है, तो Parliament can make law in regard to any class or classes of employment. ठीक है, any requirement as to the residence within that state or union territory prior to such employment or appointment. They can make a law कि okay, this is for this public employment only these particular people of this particular state can give the exam. You can't come and say कि we are like equality नहीं है, we do not have equality. You can't say, because there is a provision in Article 16 clause 3. Parliament can make. Okay. Next. So clause 3 is done. Now clause 4. Nothing in this article shall prevent the state.
Excuse me, sir.
Yes.
Sir, clause 3 is not much clear. Class employment, I'm not getting that point.
Wait. Come here. Read this. Read this. Clause 3 is, nothing in this article shall prevent Parliament from making any law prescribing in regard to a class, a particular class or a particular section, okay, or classes of employment or opportunity to an office under any government. Any requirement, like see, you get a exam, right? Some requirements will be there. You need to be of this state. You need to be of that state. Okay. So that requirement is residence requirement.
Domicile based.
Domicile based. Exactly.
Like they government make the class, divide the jobs into the classes, group A, group B.
Exactly. That is no group A, group B nahi. We are talking about residence. This clause 3 deals with residence. You know, some exams are only state of Odisha can give. Outside people can't give.
Domicile based.
Domicile based. This clause 3 deals with that only. And government can do. Parliament can do. Got it?
Can do. Okay, sir. Thank you.
Yes. So here the requirement is residence only. Okay. Clause 3. Now come to clause 4. Clause 4 says, clause 4 says, again, it will not prevent the state. Now see, there is a catch here. There is a catch here. Clause 3, residence related, state is not mentioned, parliament is mentioned. Clause 4, state is mentioned. This is the difference. And here UPSC will make question. So here parliament, any state, parliament, state government, they can make with respect to what? That only we need to know. They can make provision for reservation of appointments or post in favor of any backward class of citizens, which in opinion of that state, opinion according to them, they say they are not adequately represented, so you are giving reservation. Okay? It can be parliament, central, it can be state, it can be any state. We know what is the definition of state in Article 12, right? Mostly the government. Here state means government. Okay. So they can make related to what? Related to representation, not residence. Residence is parliament. Okay, I'm telling you very clearly, residence is parliament. So here, but here the opinion of the state is required. According to the state, they have to say ki, okay, these people or these backward classes are not adequately represented in the services, so we have to give them reservation of appointments or post. Now 4A and 4B have been added later. Okay, later they have been 4A, 4 clause A, clause B has been added. Okay, what? See, nothing in this article shall prevent the state from making any provision for reservation in matters of, now they have added in matters of promotion with consequential seniority, okay, to any class or classes of post in services under the state in favor of scheduled caste and scheduled tribes. So now they are giving them, okay, what they are giving? Reservation in promotion. This is the term which was not there here. Do you find any word promotion here? No. Reservation only, reservation or appointment. So clarity was not there. Then again after some years, again they amended and added this version. Keep promotion with consequential seniority. I'll tell you what is consequential seniority. So it will be by the state will do. Okay? But for whom? Scheduled caste, scheduled tribes, which in the opinion of the state again are not adequately represented. Clear? 4B. Nothing in this article shall prevent again the state from considering any unfilled vacancies. Now it talks about unfilled vacancies. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance to any provision of reservation made. So here it means if the vacancy for a year cannot be filled, it can be carry forwarded. They can, like the government can do, they can consider any unfilled vacancies, okay, and they can in the succeeding year they can do. Okay, this much. Clause number 5. So these two were added later. The amendment name I'll tell you is written in the next page. Not required to remember the amendment's name, but at least understand, okay, these were not there in the original thing, it came later. Okay, even in state exams they may ask you what is the amendment name for this, but in UPSC they will not ask, but in state exams they may ask you. In clause 5, nothing in this article shall affect the operation of any law. Suppose there is a law which is operating, it will not affect that law which provides, the law provides, what is that law here? Any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Suppose there is a law, okay, understand it, I'm telling you in a very clear language. Suppose there is a law and the law says in this particular institution this head would be of this religion only. We are giving, like, we are reserving this seat, the office, for only a Christian or a Hindu or a Muslim. It can also be done. It can also be done. Clear cut written here in clause 5. Nothing in this article shall affect the operation of any law which provides that, that law provides ki the incumbent of an office in connection with the affairs of any religious or denominational institutions. There are many religious institutions, right? Or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. It can be done. Now the thing is, they will ask you, this thing comes under which article? Most of the people will go with article 25, 26, article 30, nothing, all wrong. Is article 16. Okay. Okay. Next. Nothing again. Now here also they have to add, right? EWS will be added everywhere. Now they have added again here also, same 103 amendment they added. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or post in favor of any economically weaker sections of citizens other than the classes mentioned, in addition to the existing reservation, and subject to a maximum of 10%. So 10% economically reservation. So EWS comes in two articles. One is 15, one is 16. This is, both are EWS. Okay? Here admission to educational institutions. Here reservation or appointments, posts, appointments of posts. Now there is a trick here. We also studied in article 16, we studied about promotion. Do EWS have promotion provision? Yes or no? Tell me.
No.
No.
It is for SC and ST.
Yes, correct.
No,
So
not for EBS.
EWS has no promotion as of now. They have only for reservation of appointments or posts. Clear? And 10%, maximum of 10%. This is common, everybody knows it. Okay. Clear? Okay. Again, just will again go through it. So Article 16 says that there shall be equality in matters of employment, opportunity, and appointment. Okay. No citizen shall be on. These are the grounds: religion, race, caste, sex, descent, place of birth, residence. Okay. They cannot be discriminated on these grounds in respect of any employment. Now here employment, we're talking about employment, Article 16, public employment, not private employment. Article 16 is not private employment, but Article 15 is both private and public institutions, educational institutions. Okay. Article clause 3, 16 clause 3. Nothing in this article shall prevent the parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under any government. So any requirement they can have. Okay, this is the like, we're having an employment, obviously we'll get some requirements, right? Wherever you go for form fill up or something, that should be a requirement. The government can make requirement as to residence requirement, they can make domicile requirement, they can make. And here who will make? Here if they put here state government, you will get a wrong mark. So you have to be very clear. आपका एक साल की मेहनत एक वर्ड से चेंज हो जाता है. रिमेंबर, एक साल का मेहनत अगर आप डिटेलिंग और क्लैरिटी, कॉन्सेप्ट और क्लैरिटी और बहुत ही विजिलेंट वे पे नहीं पढ़ते हो तो दैट हैपेंस. ओके, स्टेट गवर्नमेंट नहीं है. नेक्स्ट क्लॉज. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens which in the opinion of the state is not adequately represented. Clause 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Okay, it can be also done. They can also, the government can make a law where they have this condition and it will not affect the fundamental rights. You cannot simply go to court and say like it is affecting or infringing my fundamental rights, the court will say you please go and study Lakshmikant and come again. Okay, study clause number 5. Okay, so in article 16, these are the things that are added, like the evolution, no need to remember. So 4a was, so first of all, clause 3 was again added in 1956. Clause 3 was not there. So how to remember? I'll tell you. See, clause 3 was not original. Okay, 1956. 4 was original, but 4a was inserted by 77th Amendment Act. 4a, this is the 4a. Okay. Then 4b was added in 81st Amendment 2000. No need to remember, it's not that important, but you should know okay, these are things which are added later on. 77, 81st, just have this number, so that if the question also comes in a state exam or any exam, so you can very easily guess कि okay, in 70s, mid 70s में there was a thing, in mid 80s में there was a thing, they will put 95 amendment, they will put 66th amendment, something, but you can that visualization, okay, you have studied, okay, 77 में कुछ changes हुआ था in article 16, 85 में there was some changes, not into go in detail what happened, you know the overall scenario, just remember the names. When you revise it in the same way. Don't go through all this because you have already studied. Just remember, okay, these are the number I need to remember. So finally, 85th Amendment mein this one 4A was added. Okay. Now finally in Article 16 that EWS was added in the 103rd Amendment. Now this is important. Question can come. State exams they may ask you. EWS में 15-16 में changes हुआ था. What was the amendment name? 15 में भी हुआ था, 16 में भी हुआ था, same amendment, that was the 103rd amendment में 15 and 16 were amended. This was the thing which was added. Okay. Principles embodied in article 16. The term reservation means, what is reservation? Now reservation is a very burning topic. Every year you can expect a question. So first of all, you have to write what is reservation. You have to give a definition. So reservation means what? It is giving preferential treatment to whom? To marginalized section of the society. You can't write giving preferential treatment to some section of the society. Some means what? You have to use this word. Marginalized sections of society in employment and access to education. That is reservation. Okay. And it is a form reservation, like from polity point of view reservation. I'm not talking about IRCTC reservation. Okay, so this is giving in employment and access to education, and it is a form of positive discrimination. It is a form because they need it, because they are marginalized, meant to promote equality. In a way, it is promoting equality only among marginalized sections so as to protect them from social and historical injustice. Okay. Article 16 guarantees equality of opportunity of all citizens in matters related to employment in public sector. So opportunity, public sector. Okay? Admission to educational institutions, public and private sector. The provisions of equality in Article 16 clause 1 is only applicable to the employment or offices held by the state, public sector only. However, the state is free to lay down requisite qualifications for the recruitment of employees for the government services. I told you the state is free. They can mention some guidelines. They can change the residence. They can change. They can only this much residence is required. We need a domiciliary requirement. They can do. The expression matters relating to employment or appointment. This is a term mentioned in the article. It includes all matters in relation to employment, both prior and subsequent to the employment. It means, thus the term guarantee in Article 16 covers initial appointments. All these things are covered. Promotions, termination of employment, matters relating to salary, periodical increment, leave, gratuity, pension, age of superannuation, etc., etc. Any matter related to employment, all these things are covered. Okay. Nothing to remember. It is self-explanatory. You know, okay, employment में ये सब चीज आता है, so it will be automatically covered. Article 16 clause 2 lays down the grounds on which the citizens should not be discriminated. We know the grounds. These are the grounds. Remember, 7 grounds. Okay. Article 15 5 grounds. Article 16 7 grounds. Okay. So the extra is, this one is extra. and residence is extra. Okay. Next, Article 16 Clause 3. Article 16 Clause 3 says, is further explanation to Article 16 Clause 2. Because it says, it is further explanation to Article 16 Clause 2, which forbids discrimination on the ground of residence. Now see how this clause empowers the parliament to make law reciting residence as a criteria for employment, which we discussed now. Parliament can make any law prescribing, okay, residence is a criteria. Only this is the thing. This is the employment. Only this domicile of these people can come and give the exam. You can't go and say ki it is against this. It is against this equality, or it is against this any kind of fundamental rights. It's infringing. No, you can't come. You can't go and say. Okay. So the thing is, see 16.2 and 16.3, how they are against each other. One clause is saying there can't be any discrimination on the basis of this, but the next clause is saying parliament can do. So when a question comes about there can be a separate question how our constitution, some provision of the constitution conflict with the other provision of the constitution in the same article. If some statement comes, you have to give these kind of examples. To write those kind of answers, you need to know articles. Otherwise, you can't write a single sentence. It will be very difficult to write. Okay. Article 16 Clause 4 expressly provides for the reservation of appointments or posts in favor of any backward classes, which in the opinion of the state is not adequately represented. Okay. Fine. Now we'll come to the judicial pronouncements, which is very much required in writing answers. Article 16 is not an exception to Article 16.1 and 16.2. We know what is 16.1, we know what is 16.2. Okay. See, on plain reading of this clause 16.4 seems to be an exception to the rest of the provisions of Article 16. But Supreme Court in State of Kerala versus N.M. Thomas case 1976 opened that clause 4 is not an exception. Further, this is not required. You need to know this Indira Sawhney case. Indira Sawhney case is a very big case. Okay. A lot of things are there. Further, in case of Indira Sawhney case 1993, Supreme Court held that Article 16.4 is not an exception, but rather it is a facet of equality, of opportunity granted in clause 1 of that article and an effective method of realizing it. It means, see, we are saying equality, but there are some people, there are marginal sections, right? And if we do not give them, then how the equality will be preserved? The term equality will be preserved. To preserve that equality only we are giving. It is not, see, it may look as an exception कि हाँ scheduled caste, scheduled tribes उनको reservation दिया जाता है, but the Supreme Court clarified कि do not see it as an exception, but see it as an equality opportunity, because we are using the term equality. How a marginal section of people can be equal with the higher class unless and until they get some benefits from the government. Once they get the benefit, that is reservation, then only they'll come to equal. No? So that's what Supreme Court said in Indira Sawhney case. This is the language you have to write. When you are reservation topic ka question aata hai, when you have to put your own answer, you have to write in this way. And it should look very simple and it should have that clarity. Article 16 clause 5 says that religious qualifications can be also described for incumbent of religious institutions. Yes. This is an exception to the general rule, because in general rule we say in the first clause, second clause, what do we say? Which forbids discrimination in public employment on the ground of religion. You can't do any discrimination on the ground of religion in public employment also. But clause 5 says you can do, in particular to this. So these are the examples of how our constitution has different faces. Now our constitution is it is very difficult to interpret. Like we are coming to a point of one clause, then the next clause we go, we are seeing it as an exception. Okay. Why the thing? Why this? Why? Can anyone tell me why they have kept it like this? Our constitution makers. Why in Indian constitution, lot of provision, lot of clauses, each clause affecting the other clause or negating the other clause? Why? Can anyone tell me? Because of diversity. Our country is very diverse. Different religion, different people, rich, poor, different subsect of a class. There is not a fixed people ki these are the people who are quite similar. No, we are very diverse nation. In the world, is one of the most diverse countries. So our constitution has taken that aspect. That's why they have made it like this, which is not wrong. It may look confused to you, but if you look deep into it, it is the correct thing, because our country needs that. If we do not keep these articles of clause 4, clause 5, if you do not keep, then our country people can't develop, because how they will get the right? They are not similar to us. Okay, they do not have the similar condition like a rich people or a middle class people. They need it. So finally, Article 16, Clause 6 was added for economically weaker section, 103rd Amendment. 10% will be given. Okay. Next. Quantum of reservation. Now, this is important from exam point of view. So here 2 cases you need to remember, not all cases. I'll tell you which you need to write in exam. I'll tell you. Okay. So 1963 Balaji case happened. So what happened in this case? Like what happened was Mysore government issued an order where reservation was provided like this. Ki backward classes will get 28%, more backward classes will get 20%, ST, SC will get 18%, and other reservation 2%. So total 68 seats were already reserved in engineering and medical and other technical institutions, Mysore government. So the Supreme Court held that the reservation contemplated by Article 15.4 and 16.4 must be within reasonable limits. It must be in reasonable limits. Generally speaking, it should be less than 50%. Okay, 68% is a very big thing. So Supreme Court held that it is beyond limits now. You can't simply give 68% to this, and what about general category then? So the court said that this 15.4 provides that state can make special provision. See, 15 is what? First of all, tell me what is 15. Today only we covered. 15 is, it is not public employment.
Admission in education.
Admission in education. So we are talking about Mysore government gave a reservation in medical institution. This is admission only, right? So the court said it is first of all outside limit. So the court said the 15.4 क्या provide करता है? It says कि state can make special provisions. This is a special provisions and not exclusive provision. In the name of special provision, you can't exclusively give this. Okay, and this reservation of 68% is gravely against Article 16.4. So it is countering. So the court said that the state would not be justified in ignoring altogether advancement of the rest of the society. You can't simply, by giving them this much of reservation, you can't simply ignore the rest of the society. Okay, what about them then? Okay. So national interest would suffer if qualified and competent students were excluded from admission into institution of higher education, obviously. So if any like from advanced group, if somebody is very much competent, so he's getting qualified, disqualified, like he's not getting, he'll suffer, right? He or she will suffer. So this was the thing which happened in this case, Mysore case, that is the Balaji. Balaji case is also important, you can use. Now there was another case in 1964, that is the Devdasan case. In this case, government reserved 17.5% seats in central services for reserved categories, but provided for carrying forward of unfilled seats for next years. In the instant case, it happened that by virtue of this provision, 29 out of 45 seats were reserved. Okay, if you calculate this, out of 40, 29 seats were reserved. The court, by following the Balaji's ruling, invalidated the carry forward rule as it exceeded 50%. Okay, again 45 से अगर 29 रिजर्व हो रहा है तो it is exceeding 50%. The court said in Balaji minimum 50% होना चाहिए, right? Okay. Again, Indira Sawhney case was not the first case to give this 50%. Before also it has been said by courts. These are the cases. These are the cases. See, generally speaking, it should be less than 50%. So Balaji case had already given something about the 50%. Yes, Indira Sawhney made it a very exclusive and very explicit statement. Okay, it should be within 50%, but it was not the first case. Previously it was there. Okay, most of the aspirants think ki Indira Sawhney case 1993, that Mandal Commission, and that was the first who started this 50%. No, it was there before also. Okay, so be very careful while seeing the vocabulary or the statement in the exam. So same thing, Devdasan case also, in Devdasan case, Supreme Court said कि okay, it is also 50%, it is increasing, it is 45 से ज़्यादा हो रहा है, right? So it is exceeding 50%. So the court upheld. So in state of Kerala and Thomas case in 1970, it is very important case. In this case, because of exemption given to SC and ST for passing departmental test for number of years for promotion from LDC to UDC, there was a some case Kerala पे हुआ था. The government gave department test pass करने के लिए something the exemption gave to SC and ST. Okay, so in that case, what happened is in 1 year 34 out of 54 posts were reserved for them. So again here also it is exceeding 50%. ठीक है? So here the court said and held that articles 15.4 and 16.4 are not exceptions, but they are emphatic assertions and directions to take affirmative action. So it confers discretionary power to make reservations, but not mandatory. You make reservation. Discretionary power is there, but it is not mandatory, right? We covered in the clauses in the constitutional articles, right? Power दिया जा रहा है, but exclusive power नहीं कि आपको करना ही करना है. It is very discretionary power to make reservation. It has to come with logic. It has to come with quantitative data. These all terms will be given later by the Indira Gandhi judgment. Okay. It upheld the carry forward rule. Carry forward rule was okay and accepted the above reasoning, considering the SC/ST population and their representation in the state services were much below. It was very low. The representation was very less. So carry forward, okay, carry forward is okay. The government also said okay, because carry forward statement was already there in the constitution. The government applied that, and the court also validated it. Okay, but they did not want. The court did not want that the reservation should increase 50%. They said to bring equality, states should make reservations up to any extent. So यहाँ पे भी the state could make could not. It's not could not make reservation up to any extent. This is could not could. It is could not. Okay. Obviously, in the name of equality, you cannot make a 68 or a 65% reservation. You can't do, right? Because there are other people also. Finally comes the Indira Soni case. Now any question can be, they can ask you any question in mains, evolution of reservation through judicial pronouncements. You have to give 2 to 3 case names, and it will be a very difficult question. It's not difficult actually, but the thing is, it is not mentioned in Lakshmikan, but it is mentioned in other books. Okay. In Indira Soni case, what happened? It was a landmark judgment. Recently also something happened in 2020, we'll come to that. But in Indira Soni case, it was held by a 9-judge bench of Supreme Court that reservations contemplated in Article 16.4 should not exceed 50%. Now here, they clearly told it should not exceed 50% of the appointments in a grade, cadre or service in any particular year. Clearly they said. It is only for extraordinary reasons that this percentage may be exceeded, but it means there is a room for exceed. You can exceed, but extraordinary. So 2 statements cannot be done, but again there is a room. Yes, for extraordinary reasons, that percentage of 50% can be exceeded. However, every excess of over 50% will have to be justified. But if you are exceeding 50%, you have to justify. You have to give data. Okay, so 50% you have to justify on valid grounds to be specifically made out. Valid grounds. The adequacy of representation is not to be determined merely on the basis of overall numerical strength of the backward classes in the services. You can't simply say this is the strength we have. No, their representation at different levels of administration and in different grades has to be taken into consideration. But it means, just remember the word, quantifiable data. You have to justify and you have to give quantifiable data. Okay, so it is the effective voice in the administration and not the total number. Number se nahi hoga. You have to give the data, you have to justify it, and you have to exactly show them everything. So this is the representative, this is the thing happening, everything. You have to give all this data, which determines the adequacy of representation. Now recently, remember the name Chebrolu Leela Prasad Rao versus State of Andhra Pradesh 2020, recently current affair case hai. Okay? Supreme Court held that 100% reservation of teachers belonging to scheduled tribe category at schools situated in scheduled areas is unconstitutional. 100% reservation of teachers belonging to scheduled tribes, not scheduled caste, at school situated in scheduled area. Scheduled area is nothing related to scheduled tribe only. So 100% आंध्र प्रदेश में हुआ था वैसा scheduled areas में, तो that is unconstitutional. Recent case. Okay. Now coming to the basis of reservation. The basis, we covered everything. The basis also I told you regarding this. This is the basis, like quantifiable data you have to justify. Regarding that, what the judgments are given by courts or Supreme Court. So same thing, Balaji case. Balaji case, it was held that while dealing with question as to whether any class of citizen is socially backward or not, it may not be irrelevant to consider the caste as a class of citizens. You can consider them, okay, you can consider the caste as a class, okay, fine, although it is not logical to make caste the whole basis of classification, but caste is also a class of citizens, because it was very at that point of time 1963, like it was not that awareness utna nahi tha. So they told ki okay, you can take caste as a class of citizens and you can give them, but it should not be like 68%. It should be logical. It should be minimum 50%. Caste furnishes a working criterion and it is also the primary index of social backwardness. So here we are talking about basis. So here caste can be taken as a basis of reservation. In Balaji they said. Okay. Indra Sawhney case mein, what was the basis? Which is also known as the Mandal Commission case. It deals with reservation in public employment. It deals with public employment, okay, and provides that backward classes is not defined. Backward classes term is not defined in the constitution. Even a caste may also constitute a class. A caste can also constitute a class. So they are also because it is not defined backward classes. So the state or the government can consider caste as a caste and can provide reservations. So it is the Indra Sawhney case also. It is agreeing ki okay, you can take caste as a class while giving reservations. The backwardness contemplated under Article 16.4 is mainly social, and the backwardness which is mentioned in Article 16.4 we covered now, it is mainly socially backward. Okay, income or extent of poverty can be taken as a measure of social advancement. Income kitna hai or kitna poverty hai, you can take this as a measure of social advancement. Ki how much it is socially advanced, or they are socially advanced or not based on income, and on the basis the creamy layer of a given caste can be excluded for getting benefit. Now here creamy layer concept came. Now creamy layer concept came for this socially backward people. They criminal concept can be given to them if they are quite advanced. So if they are coming under the creamy layer, so they will not get the benefits. So creamy layer for, now tell me, creamy layer is for whom? OBC. Criminal layer till now not for SC and ST. The government has not included criminal layer for SC and ST, but the courts have said, I'll tell you now, the courts have already said ki yes, criminal layer should be added to SC and ST, but the government, till the government will implement, things will come into place, right? Till now government hasn't done it, but for OBC it is there, and criminal layer concept came from here. The reservations contemplated under Article 16 should not exceed 50%. This is the main thing they told. Okay. Carry forward of unfilled is allowed, but up to 50%. Carry forward is 50%. And this 50% was also mentioned in the constitution we covered today. Okay. Next, what? Next, the court said there should be no reservation in promotion. Clear cut they said. Obviously it was not mentioned in the constitution also, but they cleared it. Okay, there should be no reservation in promotion. Reservation in appointment of post under Article 16 is binding only upon initial appointment and cannot extend to provide reservation in matter of promotion. Promotion pe nahi hai. Okay. The above decision of the Supreme Court has been nullified bit by successive amendments by the Parliament. But what the Parliament did, the Parliament slowly what they did, they changed it by amending the Constitution. Okay, they changed it. Why? Because political party always will go for vote banks. Okay, they will change it. So it is not mandatory that any judicial judgment is coming and you have to adhere, the Parliament has to adhere. No, the Parliament can change it. through a constitutional amendment. They will amend it. They have a majority. They will amend it and make a law. Then again, if somebody puts a PIL or the Supreme Court said, no, it is against, then again the case will go. So it is a circular process. Okay. The Constitution 77 Amendment Act 1995. So what happened? In 1995, what happened after the Indira Sawhney case? In Indira Sawhney case, it was laid that there will be no reservation in promotions. But 77 Amendment inserted clause 4A. I told you 77 clause 4A, which provided that there shall be reservation in promotion of scheduled castes and scheduled tribes, as long as the state is of opinion that they are not adequately represented in state services. Okay? They added this. 4A we covered. Then in 2000, 81st Amendment. Again, the Indira Sawhney case, they said that the reservation will not exceed 50%. Okay? And therefore, a cap or a ceiling limit of 50% applied to current as well as backlog vacancies was imposed through reservation. Okay? But what happened is 81 Amendment, they added clause 4B was inserted, which has put an end to this ceiling limit and states that unfilled vacancies to the previous years could not be filled due to non-availability of eligible candidates belonging to scheduled caste and scheduled tribes and backward classes, and will be considered as a separate class and be filled up in the succeeding years. This is known as carry forward rule. Okay? So carry forward rule उन्होंने add कर दिया. No need to remember this, but I am telling you the evolution. Just you need to have brief idea. Okay, these are the things which happened. Then in 2001, 85 Amendment. Okay? They added this. They amended the wards. Through this, they amended in matters of promotion with consequential seniority to any class. They added. Previously, there was in matters of promotion to any class. Now they added in matters of promotion with consequential seniority. This is the final thing which is happening. Till now it is there in Constitution. This is the final thing. So what happened? It provides that the person of reserved category promoted earlier will be treated as a senior to general category employee, even if reserved category employees have been appointed later on. And this is happening now also. Like your junior can also come to your place through promotion. It can also happen. It's happening in government offices. Like I have friends and my sister, everything, I've seen it. It is happening. Okay. So the most important case comes Nagaraj case, which you have to write. You have to write Nagaraj case, you have to write Indira Sawhney case. These two cases you have to remember, and any question with reservation, if you do not write these two cases, you will not get a single mark. I'm telling you, you will not get marks. In Nagaraj case 2007, what happened? So in this case, the petitioner challenged all this thing. The 16(4)(a), 4(b), these all amendments, they challenged it. These are all wrong. Okay. But in Nagaraj case, the 5 judges constitution bench of the Supreme Court, what they said? They said that these amendments do not violate the basic features of the Constitution. These are enabling provisions and only apply to SC and ST. They do not obliterate constitutional requirements, such as 50% ceiling limit. The 50% ceiling limit is there. We are not removing that. We are simply enabling something for SC and ST. Criminal, they are not. It is not like they do not obliterate constitutional requirements such as 50% ceiling in reservation. They do not. They are not said anything about the criminal layer, post-based roster sub-classification between OBC on one hand and SC ST on the other hand. They are not doing anything on that, as held in Indira Sawhney case. We are doing everything as done. We are simply giving some extra thing to SC and ST. So they do not alter the structure of equality codes, and therefore they are not beyond amending power of the Parliament. The Supreme Court laid down 3 conditions. These 3 conditions you have to write in mains. 3 conditions in Nagaraj case for the promotion of SC and ST in public employment. Kya bole? The government cannot introduce reservation quota unless it proves that the particular community is backward. So you cannot introduce reservation quota, but you have to prove it. Then you can do. So it has to be proved that they are inadequately represented, and it should be based on quantifiable data collected by the government. It is further to be proved by the government that providing reservations in promotion would not affect the overall efficiency. They also said if you are providing reservation in promotion, but it should not affect the efficiency of that organization or that public department or that office. Okay. So the Supreme Court in this case had reversed its earlier stance in Indira Sawhney case, in which it had excluded the criminal concept on scheduled caste and scheduled. Now see, very important how to write in mains. There was a question recently. So I was telling this. So in one thing, here it is saying the Supreme Court said also that the court extended the creamy layer concept to SC/ST. In Indira Sawhney, what happened? Creamy layer to OBC. Okay? In Nagaraj case, Supreme Court said creamy layer should be given to SC/ST. Now, mains question, should creamy layer be given to SC/ST? Still in news. In plus, you can write one. In criticism, you can write one case. These two cases you get. One case you have to write in favor, one case you have to write in not in favor. Apart from other points, you can give two judicial pronouncements. If you give this, the examiner will come to know that you have the correct concept. You have the correct the evolution knowledge you have. Which case is giving what? Okay, and you have to add it with other points. Clear, everyone? Now coming to Maratha Reservation, not required, but still then you can just go through it. Recent case hai. What happened is the Maharashtra government had brought a law, okay? Had brought a law where they had given reservation, okay? They had given 16% reservation to in educational government jobs for Marathas, okay? So the High Court upheld. High Court told okay, it is fine, okay? Upheld the validity of Maratha reservation, but based on the recommendation, it said ki quota to 12%, not 16, but it should be 12%. Now it went to court. So in JC Lakshman Rao Patel versus Chief Minister in 2021 Supreme Court, recent last year. So the 5-bench judge clearly said that the Maratha quota was unconstitutional. Totally it squashed the Socially and Educationally Backward Classes Act of. This was the act of Maratha government. It was also against the Indira Sawhney judgment, which fixed reservation limit to 50%. The government said, the Supreme Court said, you are again violating that 50%. The Supreme Court also held that the separate reservation for Maratha community violated Article 14 and Article 21. Okay? Because other people are also there, right? So just you have to give the example. If you get some question, you can use this as an example. How the Supreme Court, how the judiciary is setting precedent. Is setting precedent on reservation to legislature. Judiciary and versus legislature, one question can come. You can, lot of examples are there, but for reservation you can use these examples. जाट reservation भी वैसा हुआ था. जाट reservation में it's old case 2015. Again it was quashed. No need to go in details. Just it was quashed. Okay. Now creamy layer. Now again one more case 2018. Nagaraj case and this case you can write in question where creamy layer should be added to added to scheduled caste and scheduled tribes or not. If yes, you are writing a yes, then you have to give examples, judicial interpretations. One is Nagaraj case and one you can use Jarnal Singh case. Okay. In the Jarnal Singh case also, it clearly said, see, the Supreme Court said that socially, educationally and economically advanced cream of scheduled caste and scheduled tribe community must be excluded from the benefits of reservation. They should be added to the creamy layer so that they are not given benefits of reservation because they are socially, educationally, economically advanced. Case name Jarnal Singh case 2018. Nagraj case 2018, 2007. So you can justify your argument through two judicial representations or judicial interpretations. Okay. Now, whether is reservation in jobs and promotion a fundamental right? No, it is not a fundamental right. These are not fundamental right. These are just given for the state. They can do based on data, quantifiable data. You simply can't come and say you give me reservation. It is harming my fundamental right. No. Article 16.4 is not a fundamental right. It is an enabling provision which gives discretion to the state. Again, discretion to the state. It is not mandatory for the state. Not mandatory. Not mandatory for the state. Okay. Under Article 16.4, there is a twin test for reservation. There should be a backward class of citizen. They should not be adequately represented. You have to prove it. Okay. For achieving equality, it provides for reservation to backward classes in public employment. For achieving equality, it provides for reservation. Because, see, this is a double-edged sword. Okay, you have to write it in that way. It is a double-edged sword. In one way, you are saying equality. So we are giving them reservation. In the other way, the general people are saying that where is the equality for us? Okay. So this is a debate which is since India got independence till now also it is happening. So we cannot take sides. Okay. So what we can do to write an answer, we have to give various we have to give various dimensions. Okay. You simply can't put your own ideology here. You have to give various dimensions. You have to write as a bureaucrat. You cannot write as a particular like you are having a debate in a news channel. No, you have to write it as a bureaucrat. You have to give points. You have to give judicial interpretations. Okay, and you have to take both sides. Because bureaucracy में neutrality चलती है. Okay, you cannot take sides. So in Mukesh Kumar 2020 case, the Supreme Court also said there is no fundamental right which inheres in an individual to claim reservation and promotions. You simply can't go and claim reservation and promotion and say this is my fundamental right. No, this is not. This is just an enabling provision given to the government. Yes, you have a discretion. You can do it. If you find it we are they are represented very not in a very nice way, they are represented. Okay, less representation, then only the government can do it. So no mandamus can be issued by the court directing the state government to provide reservation. No, as Article 16.4 and 16.4a do not provide fundamental right. That is why the courts cannot issue direction to the state government to provide reservations. No, it is not a fundamental. It do not provide a fundamental right. So the government or the court cannot say to the government ki, yes, please provide reservation. No. Okay. However, if the state government does want to exercise its discretion and provide reservation, it would have to first collect quantifiable data showing inadequacy of representation of that classes in public services. Okay. Okay. Next, untouchability. It's a very short article. Untouchability is abolished and its practice in any form is forbidden. Okay. The enforcement of any disability arising out of untouchability shall be offense punishable in accordance with a law. What is the law? This is the law. Untouchability Offences Act of 1950. Clearly it is mentioned. Okay, it is untouchability. Clearly one statement is there, but they have mentioned it has to come. The provisions will come in a law. So it came in a law. Again, it was renamed in 1976 as the Protection of Civil Rights Act of 1955. Okay, 1976. Imprisonment hoga 6 months, 50 rupees, 500 rupees. Sorry, 50 nahi, 500 rupees or both. Okay. So in one case, 1982, People's Union of Democratic Reform Rights versus Union of India, the Supreme Court held that the fundamental right under Article 17 is available against private individuals also. Private individuals bhi agar koi untouchability, like they are doing something, you can go to the court. And it is the constitutional duty of the state to take necessary steps through this law to see that these fundamental rights are not violated. Okay. So the rights which are only for against state, and some rights are for both state and individual. You have to be very careful in that. Questions aa sakta hai. Which of the following articles are both for state and for individuals also? This is one of them. Okay. Article 15 also one of them. Fine. Now abolition of titles. This year abolition of title question came. No title not being a military or academic distinction shall be conferred by the state. No citizen shall accept any title from any foreign state. You can't accept any title from any foreign state. No person who is not a citizen of India shall, while he holds any office of profit or trust under the states, accept without the consent of the president any title from foreign state. It means you can accept, okay? You can accept while you are holding any office of profit or trust under the state, you can accept title, yes, but you have to take consent of the president. So this is the language which will come in exam. Okay, they'll not put no person, they'll simply change the statement and make it a very clean and clear statement. Whose consent you have to take? President consent you have to take. No person holding any office of profit or trust under state shall, without the consent of the president, accept any present emolument or office of any kind or from any foreign state. So you can do, but with the consent of president you can accept. Okay, so the clear-cut explanation is here. The state from conferring any title except a military or academic distinction on anybody, whether citizen or foreigner, you can't. Except military or academic distinction, you can't take any title. So military is there, military title you can take, academic distinction title you can take. Okay, a citizen of India from accepting, so it prohibits a citizen from India from accepting any title from any foreign state. It prohibits a foreigner holding any office of profit. No, it talks about foreigner. Okay, foreigner holding any office of profit or trust under the state from accepting any title from any foreign state without the consent of the president. Here it prohibits a citizen or a foreigner holding any office of profit or trust under the state from accepting any present emoluments or office from or under any foreign state without the consent of the president. So consent of the president is required in here both. Okay, now national awards are not titles, by the way. Bharat Ratna, Padma Shri, Padma Bhushan, these are not titles which are given by the court. 1996, this is the case. Okay, Balaji Raghavan case. Supreme Court held that national awards such as Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri do not amount to title within the meaning of Article 18. They do not come as a title and they should not be used as suffixes or prefixes in the name of the awardee. Otherwise, their award should be fortified. Designation like senior advocate is not a title. So senior advocate, we use it, right? It was a very recent case in 2017. Senior advocate, we use it, right? So in Indira Jaising case, Supreme Court held that the designation like senior advocate before the name of the advocate is not a title. It is not a title and it is merely a distinction. We told you that academic distinction is okay and it is not violative of Article 18. It is not violative of Article 18. So we are done with Article 18. So in next class we'll be doing Article 19. Okay, fine. Thank you.